And it shall rise. In cause number 23, CR 780, the state of Texas versus Brandon Dwayne Kirksey. We, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 65 years. It is signed by the foreperson. It is received and made a part of the record for all purposes. We are on the record in cause number 23, CR 780, the state of Texas versus Brandon Dwayne Kirksey. He was indicted for the first-degree felony of aggravated sexual assault of a child. The court has received a message from the jury that the jury has reached a verdict in this case. I'm going to ask the bailiffs to bring the jury forth, and let's get the alternate first, and then we'll bring the main body of the jury in and receive the verdict. And the record shall now show that the jury is seated in the courtroom, and I'm going to ask the jury foreperson if you would be so kind to rise. Please stand up, and we're going to ask you to present the verdict in just a moment. The court has received a message from the jury that the jury has reached a verdict in this trial. Is that so, sir?
Yes, sir.
Is this verdict a unanimous one? That is, one that is agreed upon by all members of the jury?
Yes, sir.
Do any of the jurors disagree with your foreperson's representation? No disagreement. It does indeed appear to be a unanimous verdict. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish this verdict. The defendant shall rise. In cause number 23, CR 780, the state of Texas versus Brandon Dwayne Kirksey, we, the jury, find the defendant guilty of the offense of aggravated sexual assault of a child as charged in the indictment, signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes, and you may be seated. At this time, ladies and gentlemen, the court has received your verdict, finding the defendant guilty of the charged offense, the first-degree felony of aggravated sexual assault of a child. This brings us to a close of phase one of the trial, a bifurcated trial, two parts. We are going to proceed next with the punishment phase of the trial. Please be mindful you are still under all the instructions that have been given to you previously. All right. There is the second, before we break, there is the second paragraph here, which is not going to be relevant in this matter at this time.
Correct.
All right. Ladies and gentlemen, we're going to take a break for lunch. Can all of you be returned back at 1:50?
Judge, can you do that till 1:30? I've
got a better idea. How about 1:30? Please, if you go with other jurors, talk about the weather, everything else, not about this case. But again, these instructions you are required to follow until the end of the case. And let's return back at 1:30. All right. Everyone else remains seated while the jury exits first. Thank you. Yes, sir.
Am I required to return, Your Honor?
Yes, sir. Thank you until the end. Thank you. One other thing, for the record, we cannot make outbursts in front of the jury. That is inappropriate. And if you cannot compose yourself, you must remain outside. These are difficult for everybody, but people are not allowed to be emotional in front of the jury. That can only be determined to be a possibility of someone trying to influence the jury. We still have the punishment phase. You're going to stay outside, ma'am, until the conclusion of this trial. Thank you. I'm sorry, you can't unring a bell. This jury has already seen and heard you, and that can affect them. And this court can't allow that. The jury has to be focused on its job, not listening to people who are making outbursts. And that is inappropriate. You will remain outside Thank you. We're in recess. One other thing, before everybody leaves, Mr. Kirksey, anytime you want to bring him back to help counsel you, you may. Right now, you're representing yourself, and there are serious disabilities to doing that when you're not legal expert and has tried cases like him. If at any time you wish to get him back to represent you, he's standing by. If any time you want Mr. Wilkerson to get back to represent you, you let me know so you can be guided. Because you know, there's an old saying, it's a foolish person who represents themselves. And that's that. I didn't make that up. It's a fool who represents himself in a criminal trial because it is it disfavors you for many reasons. And there's so much at stake at every trial in this room, but defendants representing themselves seldom do well because there's so many dynamics that require education, law school training, and experience that go into trial work that just people who aren't who don't do this for a living aren't able to do it. What do you do for your living? I mean, when you were Freeman, what's your abilities?
Carpenter.
Let me tell you, I'd probably saw off my hand first thing. See, that's why I would have to have something. I couldn't do that right off, and I certainly wouldn't be able to make something that's an art form without experience and training and being careful about the tools that you use, since those can be lethal. The same thing applies here. So, anytime you want him to help you, well, you can. Okay, but please be mindful of it. Think about it.
Yeah, sure.
All right. And let me know if you change your mind.
I do. I
Sir?
I do. I change my. I like it too. I just want.
All right. All right. He wants you to help him.
I just want to be heard, man. That's it.
So y'all, Mr. Wilkerson, go go back there and discuss whatever he needs because we still have a second phase to deal with.
And that's the question, is it, I mean, I'm standby, but do I do punishment or am I just here to
Y'all talk about it.
advise him?
Y'all talk. He's wanting you to help him find out what that means, and then pass it to me. And if he wants you to continue to represent him for this punishment phase, then I'm going to ask you if you'd be so kind to do that to help him.
Yes.
Thank you. We're in recess.
That's the question. Oh, yeah. I can't have it in the chair.
Thank you. All right, we are in recess until 1:30. And the defendant is present. All parties are present. Mr. Kirksey, we have received a message from the jury that the jury has reached a verdict in this punishment phase of this trial. And whatever the verdict is, we'll find out about it all at the same time. Please be careful about any outbursts that may be made. That would be inappropriate, and we don't want anybody disciplined because it is an offense to make an outburst in court. We've reached a verdict in this trial. Again, thank you for your patience, sir, as the alternate in this case. And I ask the bailiff to please bring the jury forth. The record shall now show that the jury is seated in the courtroom. Mr. McFarland, as foreperson of this jury, we have received a message on your behalf that the jury has reached a verdict in this punishment phase of this trial. Is that true, sir?
Yes, sir.
Is this decision by the jury a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, it is.
Do any of the jurors disagree with your foreperson's representations? No disagreement is indicated. It does indeed appear to be unanimous as required. If you would be so kind, pass the documents to the bailiff. You may be seated. Thank you, Mr. McFarland. The court will review for proper form and publish the verdict. The defendant shall rise. In cause number 23, CR 780, the state of Texas versus Brandon Dwayne Kirksey. We, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 65 years. It is signed by the foreperson. It is received and made a part of the record for all purposes. The parties may be seated. Ladies and gentlemen of the jury, I have received your verdict in this punishment phase. Assessing the defendant's punishment is 65 years imprisonment, and you will be discharged and released from your oath of secrecy. You are free to discuss this case and your deliberations with others. You are also just as well free to refuse to discuss this case. And you have every right to maintain your silence unless otherwise ordered to do so by me. The court has to go through some formalities here in a few minutes, and I'm going to be releasing you first before we have to do the formalities that the law requires. But the parties will be released in about 5 minutes. And a lot of times the jurors want to ask questions of the lawyers. These are fine people who are going to be happy to answer any questions they're able to of you. If you feel like there are some things that you're curious about that you need clarification of. So they will be released here in about 5 minutes. If you would be so kind to wait that length of time, you're also free as well. And again, you can discuss these matters with others now. We have tried 600 felony jury trials since I've been here, which I think is a world record, but it just shows that we're busy. We have issues in the county that we are addressing, but the whole system works together. We can't do it when defendants ask for a jury trial. It's part of the Constitution and the Bill of Rights, and we have to have jurors, people who are willing, ready, and able to serve and serve responsibly as jurors. So I want to thank all of you for taking your valuable time to be a part of the United States of America, Jefferson County, Texas, working under the laws. I hope to have the honor to work with you in the future. But until then, may God continue to bless Jefferson County and its citizens. And you are excused. Thank you very much. Arthur, take care. You wishes to you and the family.
All right.
Marcy says hello.
Thank you. Let's see you. Appreciate it. Michael's telling you that. I said,
All right. At this time, is there any legal reason why formal pronouncement of sentencing should not be made? State
there you go.
No,
and defense. You may rise, please, sir. Brandon Dwayne Kirksey, you came before this court and a jury, entered a plea of not guilty to the offense of aggravated sexual assault of a child, as set out in the indictment. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of this first-degree felony. Thereafter, evidence was presented. The jury deliberated and determined that you should be punished for a term of 65 years in prison. Is there any reason why formal sentencing shall not be made at this moment, state or defense?
No, no.
Therefore, it is the judgment of this court that you are guilty in this cause number 23 CR 780 of the first degree felony of aggravated sexual assault of a child younger than 14 years of age. And that you shall be punished in accordance with the jury's verdict. And finding nothing to bar pronouncement of sentence against you, you are hereby sentenced based upon the jury's verdicts of confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 65 years. You will be given credit for all time you have served in accordance with this case. Is there anything else we need to add by either of the parties, state
No.
or
No,
defense? You are here now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out these directions and instructions of this sentence. These proceedings are concluded, and we are in recess on this case.